report is State of Maine versus James Green. This is Penobscot 23246. We are being streamed live on the web, both by video and audio. Before we begin, I would ask counsel to identify yourselves by saying your names for the record, together with the party that you represent.
Zachary Smith for James Green, the appellant.
And Mark Rucci for the appellee, State of Maine.
Thank you. And Mr. Smith, if you're ready to proceed, we'd be happy to hear your argument.
May it please the court. This issue isn't going away, regardless of the central issue here is not going away, regardless of the disposition of this appeal. I understand most criminal appeals result in an affirmation of the judgment below. There may end up being some procedural ground here that this court may decide I've forfeited an argument or I didn't properly preserve it or else there might have been harmless error. But the issue of discovery and the appropriateness of a DRE, so-called drug recognition expert or evaluator, testifying is something that's going to continue. I've had at least 2 cases since this trial myself, as just one of many defense attorneys in OUI cases in this state, where similar issues have come up involving the appropriateness of the purported expertise of this kind of witness, as well as the extent to which I'm entitled as a defense attorney or a pro se defendant for that matter, to discovery of standard kind of expert witness reports. And someone recently filed a motion to compel discovery in a case that we resolved by plea agreement, but the exact same kind of report that I asked for in this case, apparently not in a clear enough manner, the state, the same DA's office, took the position I'm not entitled to get. So I think this is going to continue to come up, and what we're ultimately going to have for an issue is, you know, the extent of discovery, which I don't think the state's position is tenable. This is a standard kind of expert witness report in all kinds of cases, and I don't know why that would be any different in a criminal case as opposed to, you know, a tort case or you know, professional negligence or something of that nature. That's my opening statement. If the court has any questions.
Counsel, I guess you received the DRE report, correct?
Yes.
Okay. That report outlines that witness's observations and conclusions.
Yes.
And the reasons for his conclusions. In that case, I understand it doesn't go into training or, you know, what the scientific basis is or anything like that.
Right, in a very summary fashion.
Okay. But there was no motion to comply, to ask the state to do anything further.
I understand that, and I understand this court may say that I didn't do what I was supposed to do, but I did in fact ask for that discovery, and the fact that the state didn't object to that gave me a false sense that there wasn't going to be such expert
You knew that the
testimony.
DRE was going to testify, right?
Yes.
Okay. So what was your false sense of what?
My sense was that this person was going to testify as a standard law enforcement officer and not offer the kind of pseudoscientific testimony that DREs give at trials throughout the state.
Okay. But when it came to the trial, there were no objections to any of the opinion questions or anything like that, were there? Did you object to any of the questions?
I don't think I did. The state never even offered him as an expert. And then again, the court may decide ultimately that I failed to preserve some objection, but this issue is not going away.
But I guess what testimony are you objecting to? That's what I'm not
anything
clear.
that goes beyond just what he witnessed himself, the way a normal witness would be able to testify to.
But how are we supposed to parse that out if there's no objection to any of the questions?
Well, Your Honor, I've objected to it at a subsequent trial, and
At a subsequent trial?
yeah, different case, different OUI
Okay,
case.
that's not before us.
Right. So what I'm saying is that, yes, in the future, I will do a better job of preserving my objections.
So here, you're on obvious error, obviously.
Yes, I'm bringing this as more of a constitutional due process argument.
So can you point to some specific testimony that you were prejudiced by? If we've, obvious error is a pretty large hump to get over, but if you can explain to us, in other words, that he testified to X, Y, and Z, and if I had further discovery, it would have changed things in this way. Are you able to come up with any concrete specifics like that to help us get past the obvious error obstacle?
Well, I would need to go over the transcript in great detail, but I know specifically he said, well, these different observations I made about his temperature, my client's temperature, and his eyes.
Yeah, he stepped through the whole thing. There's a lengthy process
yes,
about he
it's a bunch of observations, and then.
But that stuff you would have known was coming because that's part of what DREs do. You do this kind of work, and when they testify that they say, we take their temperature, we take their history, all the rest of it. And
I had no way of knowing what exactly he was going to testify to, because this is, as I mentioned in my brief, this is different from expert witness testimony where civil rules there shouldn't be any surprises in a tort case, and somehow the due process is lower.
okay, but you can't tee up any of the specifics for which we could say on page 94, line 52, he said this and that sort of.
There was a bunch of things where he said, oh, well, this is consistent with someone who's under the influence of CNS,
right.
Central nervous system depressants. It's all that kind of testimony beyond just.
But don't you have to move, I guess that's the problem, I feel like there's two different things going on here. One, whether there was a discovery violation, and
Yes.
then two, the scope or the competence of the witness. And without specific objections to questions, in other words, anybody, whether a law enforcement officer or for that matter, might be qualified to answer an expert or an opinion question on one thing, but not necessarily on all things.
Right.
By virtue of his training, he might have been qualified to answer some, but not other questions. And I'm just struggling to understand how we're supposed to address that when there's not an objection to any of the questions.
Well, at the outset, I believe that the failure to provide me with appropriate discovery created a due process argument more than anything else. I was not able to engage in effective cross-examination of this witness.
What discovery did you not receive?
The kind of discovery that's an expert witness report as described in Rule 16.
Did the state prepare such a report?
No, the state did not. And
So the state doesn't have an obligation to prepare something just because you request it, does it?
you're right. I didn't know that the state was
That's
going to.
not discovery. You had a full opportunity to cross-examine this witness, didn't you?
I did, but-
Cross-examined him on his training, on his lack of ability to make it, or failure to make a diagnosis, on his not being able to testify as to the validity of the, you had a lot of questions for him on cross-examination.
Well, if I had had the kind of expert witness report that I asked for in my standard discovery
There
report.
was no report, was there? That's my
what I was
question.
asking for.
But there wasn't a report to discover, was there?
Right, I understand that. So what I asked for in my standard letter was a report of an expert as described in a very specific subsection of the rule. The state did not give me that. How am I supposed to know that I need to file a motion to compel discovery? I have subsequently done that, and I've litigated that, and the state has taken the position that I'm not entitled to such a report, that I'm not entitled to anything else beyond what is already in the boilerplate DRE report.
So your request then is to have the state prepare something above and beyond what you're getting here, that perhaps this wasn't done, but we want you to go back to this officer and have him do this, and prepare it for me.
That's
Okay.
exactly what I'm asking for. And I have changed my standard discovery response and directly after this trial, probably the next day, to make it absolutely clear to the state that that is what I'm asking for.
Well, your motion, the motion in limine, paragraph 11, appendix page 23, requested a, quote, standing order, unquote, that prohibited the use of the term expert or any expert inquiry. And the court declined to issue a standing order, but indicated that it was going to take it question by question. In other words, if you felt a particular question was intended to elicit expert evidence as opposed to lay testimony, the court specifically indicated that there could be a sidebar conversation, et cetera. And I certainly agree with you that some of the inquiry of this DRE expert did shade into expert testimony. Some of it was lay testimony, it seems to me, but not all of it. But there was no objection, there was no request for a sidebar when the question elicited expert evidence. So where does that leave us?
Well, Your Honor, in the surprise of a trial, in the heat of a trial with very little time to prepare, I guess the court may say, well, you failed to object and you failed to preserve your objections. But the larger problem of failure to make discovery upon request remains in this case, and it has due process confrontation clause effects on my client and my ability to bring an effective defense. Given the proper discovery that I'd asked for, I could have made a further motion or further developed motion in limine to preclude any, more substantively, to preclude any use of this individual as an expert witness, which I, have done since then. And again, I believe this issue is going to continue to come up, and this court may decide on failure to preserve, but the issue is not going away.
But you did extensively cross-examine credentials, experience, and all the rest of it. And again, going back to obvious error and the prejudice you need to show, you did a fairly extensive job with what you ordinarily would undercut an expert witness with. And I'm still looking for that smoking gun or that golden bullet, that you would have found had you received the report that you're looking for, but you didn't have it and you couldn't use it.
Well, I came away from it still not knowing exactly what the process is, what the program is, and how any DRE connects, a set of observations with a conclusion, pseudoscientific conclusion in any given circumstance. And something in writing before the trial would have been giving me at least adequate time to prepare and some notice of what he was going to say. During trial is not exactly the ideal time to come up with a defense strategy, and that was the situation I was put in here.
Thank you, counsel. Mr. Rucci?
Madam Chief Justice, good afternoon, and may it please the court. Deputy Barrios' testimony in this case, including his opinion testimony, was inevitably going to be put on the record for the following reasons. One, our position is that the state did not commit a discovery violation and in fact complied with the rules appellant alleges it violated by providing a report of the individual who testified as a drug recognition expert. Two, Attorney Smith did not object. Had he objected and had the court sustained the objection and ruled that the testimony proffered really constituted expert testimony, the state would have gone back and moved to tender Deputy Barrio as an expert in the field of drug recognition. The foundation on the record I would submit was sufficient that would have been accepted. Finally, 29A MRS 2525 can be read from my perspective only two ways. That is either the legislature saying that the testimony at issue today is admissible as lay testimony so long as the officer is certified, or any officer certified pursuant to the relevant standards is an expert and can give testimony as to his evaluation. Either way, the result is the same. The testimony was admissible, and Attorney Smith cannot establish obvious error in this case. And I would open the floor for questions.
I would like to go to the discovery issue then. I understand the difference between automatic discovery and discovery pursuant to court order. But really wasn't the request in this case, which asked for more than simply the report of the DRE, but asked for I think well, we don't actually have the request, I think, but it asked for some other materials. As I understand it, the CV, the basis of the opinion and things like that. Wouldn't that be really a request pursuant to 16C1, to which the state has an obligation, even if there is none, to say there is none? In other words, to have an affirmative response.
Your Honor, and I believe it's established in the record that Mr. Smith's discovery request did not request a CV. It requested any reports or statements of experts made in connection with a particular case, including results of physical or mental examinations and scientific tests, and also referenced the discovery pursuant to court order under 16D4, which is an order of preparation of report by an expert witness. From my perspective, the state provided a report. It was not requested to provide a CV. The record is, I think, is clear that the judge asked Attorney Smith about that, and he said it was not part of his standard discovery request at the time. So I'm unclear, as Justice Douglas asked at the beginning, what the state was supposed to have provided that it did not in this case.
Well, I wanted to probe a little bit more about the statements you made in your brief that he was only giving lay testimony. I mean, this is clearly expert testimony. Section 2526 says there's a program, and the officers who have completed this can testify as experts under Section 2525. They're called DREs. So if they are experts, and I understand you said you had 3 different reasons, but assume that this person is giving expert testimony. So, and under the statute, Section 2525, it seems they can give testimony about their assessment. So where do we, if you think that there is lay versus expert testimony here, what falls on the lay side and what falls on the expert side?
I would say that the only thing from the state's perspective that may fall on the expert side, Your Honor, is the ultimate opinion that the defendant is impaired by this, and this. And the reason I say that, Your Honor, is we unfortunately live in a society where it's increasingly common for people to have the opportunity to view people who may be under the influence of drugs. And I think that sort of opinion, even had the officer just said it was my opinion he was under the influence of drugs based on everything I observed, I think that that is proper as lay testimony. Now, whether he can tie that to, and I think that
But
it's
I'm going to
these.
challenge you a little bit on
Sure.
that. And just as in Abdullahi, I mean, isn't the problem, though, that when you start to say to the jury, even if it's with a wink or a nod, the reason you should believe this person's testimony is because they have a lot of experience, a lot of training, et cetera, you are treating that witness as an expert.
Well,
Whether or not you ask that ultimate opinion question, aren't you treating that witness as an expert?
I would suggest that, I mean, at least my practice in every trial is to bolster every witness, including every law enforcement witness's testimony as much as possible. If that includes, hey, you've been involved in 30 drug recognition investigations, haven't you? Yes. And you've attended A-RIDE, haven't you?
And aren't you then really saying, therefore, jury, you should pay more attention to this person's opinion than to somebody who hasn't, i.e., that this is someone who, by virtue of training and experience, has a better or more informed view?
I think that I think State v. Abdullahi is a really susses this out a little bit in a very sort of informative manner. But I think the question, or the ultimate designation as an expert, while it is, you know, while there is a definite line, Abdullahi says, that line is...
Why not just designate him as an expert?
That was my question.
Why don't you want to put him on as expert? I don't understand.
Why are you arguing it was lay testimony? You've got a statute that says it can come in as expert. There was no objection.
You gave a report.
Well, I don't even know that the statute says it can come in as expert. I think it just says it can come in. If they're certified, they can testify. So I don't know that it says can come in as expert. I think it just...
That's Section 2, that's the next section that says that they can testify as experts.
Well, then I'm sorry, Your Honor, and I clearly didn't read far enough.
And you received, to that point, not you, but the court gave an instruction on expert witnesses.
Yes.
So it's all over the place.
We're trying to figure out why you're running away from it.
There's no good Your Honor, I'm not running away from it. I think that it would have been fine, maybe even advisable to testify as an expert, but does the fact, we're here today to determine whether the fact that he was not so designated, does that constitute obvious error requiring reversal of this verdict? And in light of the lack of objections, in light of everything that was heard at this trial.
Well, are you conceding that he would have had to have been designated as an expert given the state of the discovery in this case?
I'm not conceding that, no.
Okay.
I think that...
I thought I heard you saying, given that he wasn't designated as an expert.
I said that maybe that would have been... what I meant to say was that maybe that would have been the better course of action, but I'm not conceding that it was necessary for him to have be able to give his opinion, or that failure to do so constitutes obvious error. I just don't see that, Your Honor.
So some lawyers turn to the judge and say, I ask that this witness be received as an expert witness. And typically, if I approved it for the grounds there, but I've always wondered, why do you feel you need me to sort of pre-bless this?
Sorry, what was that? Could you ask that question?
Some lawyers, after they've taken out the qualifications, they turn to the judge and say, Your Honor, I ask that Dr. Jones be received by the court as an expert witness. But I always questioned why they felt they needed the judge to put some, maybe I guess for later appeals, but whether that serves a purpose. If the witness has testified to education, experience, qualification, and so on, and they testify as an expert with no objection, and the judge gives an instruction as an expert witness, what's the purpose in getting them, quote, qualified by the judge?
I would think just as a procedural matter, Your Honor, to queue up that issue, I think, you know, you're going to get the defense attorney objection that this person hasn't been designated as such, and maybe a judge says, well, they don't have to be. They can just offer this testimony, but I think a lot of times it's probably just the cleaner way to do it.
Of course, that leads us back to what I said at the beginning, is somebody might be an expert, and even a physician might be an expert on some things, but not others.
Not everything.
Depending on what the specialty is, what the information is, and everything else. And that's why the questions have to be objected to.
Yes, and again, well, to Your Honor's point, without the questions being objected to, it's very difficult to now go back and suss out what is expert testimony that this person cannot offer an opinion to versus what is expert testimony that this person, as someone with X hours of training and as X DRE evaluations under his belt and X experience in the field, what can he testify to as an expert? Here we don't have that sort of record, and I would submit that it's not obvious error for the court to have allowed that testimony in and not sua sponte said, hold on, you know, I pump the brakes.
You know, on the civil side, when somebody identifies a person as an expert witness and does the disclosures, there's always a deposition or interrogatories. They really dig in deep to find out what this expert is going to say at the trial. On the criminal side, the defense doesn't seem to have that same prerogative to have to do a deep dive absent the agreement of the expert or the district attorney.
Or absent a motion. You know, you could file a motion, you could file the report that was provided by this DRE with the motion and say, this is not sufficient from which to prepare my case. I understand that Attorney Smith is saying he wasn't really on notice, but I take some umbrage at that because this report was provided at the outset with initial discovery. It does state exactly what exactly what Deputy Barrio could be expected to testify to. There was enough in discovery there for defense counsel to say, gee, if this is what he's going to testify to, I don't know what the basis of that training is. I don't know what the basis for the conclusion that CNS depressants do or do not cause this is, and to make that motion to the court. That was not done, and I think from the state's perspective, that's not a discovery violation. That's a report that defense counsel felt was inadequate and had certain procedural mechanisms available to them to try and remedy that inadequacy.
Well, I'm still a little hazy on the statute. Section 25252 says that if the law enforcement officer is certified and they conduct a drug impairment assessment, that officer's testimony regarding that assessment is admissible. So what is the testimony regarding that assessment that is lay testimony, and what is the testimony regarding the assessment that is expert testimony? And does the statute allow both, one or the other?
I think the statute taking the second part of your question first, my position is that the statute allows both, because if the legislature wanted to limit it, we can assume they would have known how to so limit it. And the first part of the question was, forgive me?
Which part would be lay and which part would be expert, so that you would have to designate them as an expert, hopefully?
From my perspective, lay testimony is testimony that's based on perceptions, observations, things like that. I keep doing that. Drug recognition evaluator Barrio also testified pretty extensively about his experience, his own perceptions, where I could agree with the court or see where the court is coming from is to say, not only is someone impaired, but someone is impaired by these categories of drugs. That may take specialized training that is not within the ability of your ordinary layperson to understand. But the idea that drugs can make someone's pulse go faster, the idea that drugs can make it
Well, it can make it go faster or slower. I mean, really? You're suggesting that what happens to a pulse rate as a result of drugs is a subject of lay testimony for anybody to say?
I respectfully, Your Honor, I am suggesting that a number of these medical designators are within the ability of a layperson.
So if we break it down, if he says, yes, he appeared, his eyes were droopy and he seemed to be very sluggish, is that expert or lay?
I think that that's lay testimony, and if he says...
And if he goes on to say, this is typical of opiate use, then we've gone into expert.
I would concede that that could be expert testimony, Your Honor.
Which is what he did. So he did testify as an expert.
I think that this court could be, yes. I mean, I think that
You're
there
not going to let that go, are you?
What? What was that?
You're not going to say, all right, fine, yeah, he testified as an expert.
But does it matter? The statute permits
Right.
it.
Yeah,
That's really the question, isn't it? That it may not matter.
ultimately, I think it sounds trite to say it's a distinction without a difference, but my point would be that that testimony is coming in regardless.
There don't appear to be additional questions. Thank you.
I'm sorry, I walked away before that. Thank you, Your Honor.
That's okay. I wasn't looking, and I looked up, and I was like, oh, there he is, gone.
You don't have to bow either.
Mr. Smith.
I just want to reiterate that the state's premise seems to be that as long as we check off some boxes and the person satisfies the statutory, the proposed witness satisfies the statutory requirements to be a DRE, that they have to be allowed to testify, and I don't think that can possibly be the law. That would be absurd.
Isn't that what the statute says?
It's what the statute says, but the statute does not say the person has to be allowed to testify.
Well, it says it's admissible.
It's admissible, not mandated. There's no language in there indicating it's mandatory. And even if there were,
But
we live
it's
in
going to come in unless defense counsel do something, right?
Okay.
Motion in limine, or objection?
Right, but I want the court to be aware that I don't accept this. I want to point out the premise how absurd it is that there's no limit, apparently, to take the state's position to its logical conclusion on the admissibility that the
But doesn't
court-
that circle back to exactly where we started, which is that someone might be competent to testify or render an opinion on one point, but not necessarily another point, and that's why it is critical that defense counsel identify where or specifically what you will or will not tolerate.
Yes, but I think even more fundamentally, whether the person is even allowed to testify at all, to take my understanding of the state's position in its brief and in oral argument today is that as long as they check off those boxes, the court has to allow the person to testify. And that
Well,
can't
there wouldn't have been
possibly be
any
the law.
grounds for keeping this deputy off the stand entirely. I mean, he had observations. He personally observed.
In this case, yes, but the state's position seems to be that as long as they fulfill those statutory requirements, the court cannot keep the person off the stand and cannot prevent them from
But
testifying.
they can still be challenged on this. If he says something like, oh, yes, his pulse rate was 120/7, and from that I conclude that he has consumed 0.2 grams of opiates, and defense counsel said, whoa, stop right there. What's your basis for that? And he would not have an expert ability to get to that level of detail. But he can testify, but he can be challenged.
I don't think simply the ability to challenge is quite adequate for the defense if we're allowing people to give, testimony no matter what. I think.
So what more would you want in that situation? What would you have liked to have received if a police officer is going to give that kind of testimony?
Some explanation of how and he couldn't really explain this on the stand because he doesn't know, because none of them really know. They're not adequately trained. The science behind it, or something resembling a scientific explanation for how the observations tie to his conclusions, and there isn't any. They don't know. They take like a 3-week course.
Thank you,
Thank you.
counsel. Thank you for your arguments today. And with that, we will take the matter under advisement to issue a written decision in due course and be in recess until the next matter.
All rise.